in other parts of the world, the definition of what constitutes rape is slowly broadening. The Swedish Parliament has passed a bill that sex without consent constitutes rape, even when there are no threats or force involved. The new law stating that a person must consent to sexual activity with words or clear body language. Sweden's decision reflects a wider discussion on affirmative consent laws that's gathering force across the globe. This as countries like Germany and American states such as California add consent-based reforms to their legislation. Joining me now is Dr. Olivia Smith, a criminologist from Anglia Ruskin University in the UK. Thanks for your time. The notion of affirmative consent is certainly gathering steam. Do you think other countries are likely to follow suit?
Yes, absolutely. We're increasingly recognising that rape is not just about violence or force, and so we're recognising that consent is something that's important for both parties. However, in those discussions, it's really important that we keep a sense that consent is very nuanced and also ongoing. So just saying yes once is not enough, and that has to happen in our discussions as countries move forward.
Are attitudes towards rape laws changing in this era of Me Too?
There's now much more recognition of the prevalence of sexual violence, and that's come from Me Too. However, there's an ongoing mistrust within culture. Women are still seen as more emotional than men, therefore more likely to be liars, and therefore they're not as believed. There's still a fundamental disbelief that many women are honest when they make allegations of rape.
And Olivia, you're talking there about how the onus is on the victims, on the women themselves, to prove that their story is true. And that itself is very tough, isn't it?
Yes, legally, it has to be the woman, the prosecution, who have to prove something has happened. And that can be really difficult because that's the opposite of what women need. When somebody has been raped, they fundamentally need to be believed, they need to have a sense of control over their story. And that is not what's possible within the legal system. And actually, within society, we also disbelieve women, particularly women of colour and women with mental health problems or disabilities. So we need to change the culture before we can change the law.
Yet again, in the United Kingdom, the Director of Public Prosecutions has recently apologised for failings in the criminal justice system after a review found that 47 rape or sexual offence cases were halted because evidence had not been properly shared with the defence. Now, this caused an outcry in your country and again reveals just how difficult it can be to prosecute rape cases.
Yeah, there are a number of issues here. Firstly, it's incredibly difficult to prosecute rape cases. The conviction rate for rape in England and Wales is only around 7% of cases that are reported to police will end in conviction. That's very, very low. The second thing is that actually disclosure is very complicated. It's about making sure the defence get the evidence that might help their case, and that's obviously important, but it has to be reasonable. And within rape cases, it's being very invasive. So we're expecting the victim to give their mobile phone over, to give access to all social media, medical records, counselling records, and actually there's no recognition of they have a right to privacy as well. So we are protecting the right to fair trial, but we're not necessarily considering the victim's rights within that.
Olivia, you spent 13 months observing rape trials in court. What did you find?
I found three main things. So the first is that the practicalities of going to trial were actually really difficult. So the victim was expected to go into the same entrance, they might be in the same smoking area, and so they were bumping into the defendant when they were in court. They were also being heckled. I saw people being heckled by friends and family of the defendant, and actually one victim left court to try and commit suicide because it was so stressful. The second thing I found was that there were myths and stereotypes about rape, who rape happens to, who does it, what happens afterwards. And these were fundamentally rooted within wider societal stereotypes about class, disability, gender. So, for example, I saw one victim being asked about drinking wine out of a mug rather than a glass as a sign of consent. And the third thing is that the right to a fair trial is a very important thing. We need to protect defendants' rights. However, they are being misinterpreted as the right to a favourable trial. And actually, everybody in that courtroom has human rights, and those other human rights are not being considered. We need to recognise that actually the criminal justice system probably will never be perfect. The criminal justice system will always have to test victims' evidence. The onus will always be on the victim. And so we need another set of sustainable funding for victim services so that they can have justice separate to the criminal justice system.
Olivia Smith, it's been great speaking to you. Thank you.
Thank you.